Welcome back to Todd's podcast. Before we begin today's episode, I'd like to inform our listeners that our discussion today includes sensitive topics such as gun violence and examples of suicide or self-harm. These subjects may be disturbing for some individuals, so listener discretion is advised. If you or someone you know is struggling, please seek help from a mental health professional or reach out to the available resources in your community. Thank you for understanding. Well, hello everyone, and welcome to Todd's podcast. Today is going to be a departure from our usual type of podcast as we discuss an order that was created and enacted into law in reaction to the Parkland mass shooting in 2018. It's called the Florida Risk Protection Order, or the Red Flag Law. And while our conversation today may be focused towards Polk County, just because our guest is a Polk County attorney, this is a horrible tragedy that affected citizens all across our state and still has reverberations. So I want to introduce our guest today. His name is David Carmichael. He is an attorney, a defense attorney, and a prosecutor in a previous life. He's board certified as an expert in criminal trial litigation. David is a partner with the law firm of Boswell and Dunlap, where he acts as general counsel for the Lakeland Police Department and represents 6 other local police departments in Polk County in court, as what the Sheriff's Department is one, and other few municipalities around Polk County. Is that correct?
Right.
Okay. So he's got more than 30 years of practice and more than 20 years of teaching college courses on constitutional, both here and in China, which maybe we'll have a moment to talk about China, but you have to speak in English so the rest of us can understand it. And over the last 5 years, he's primarily acted as general counsel to numerous police agencies, where he has come to be a national leader with more than 600 risk protection cases and resolutions since its inception in 2018. David has conducted probably more RPO hearings than any other single person in the country. And there's a lot of constitutional issues that are touching this topic, and there's very few appeals, and I do want to kind of get into that as we go along through the process, David. So welcome. Let's start off with a little history of why Florida enacted this law, where we are we the only state in the union that does this, some history of how it became a law. Just give us some background that we need to know.
Florida is not the only state that uses something that we euphemistically call red flag laws. Florida became particularly interested in enacting a red flag law after, as you alluded to, the Marjory Stoneman Douglas High School shooting. The red flag law, as you might call it, I'm going to refer to it as a risk protection order, or an RPO. So for football fans, that's a run-pass option.
Right.
But in the legal world, it's a risk protection order.
Okay.
Florida became interested in it in the reaction in the immediate aftermath of the shooting down south. And they built it initially in a bit of a fury. Some legislation that we see in Florida with usually associated with a victim's name, the Jimmy Rice Act, the Kayla McKean Act, risk protection orders are often put together after a tragedy has happened because legislatures see a need for it. Here, to keep it as brief as possible, the legislature, in a bipartisan fashion, very quickly got together. They put together the bones of a red flag law that they had seen in other states, created a civil risk protection order, which is a multi-step process where law enforcement officers, if they become aware that an individual is making a threat to harm themselves or another person with a firearm.
Only a firearm.
Well, that's a good question. There are aspects of this which would say if a person has firearms and has made threats or has access to firearms and continues to make threats, and I'll go through some of those elements a little bit later, you could obtain a risk protection order based on other types of threats, but firearms are the triggering issue. So the legislature put together this 2-stage action, and basically if law enforcement becomes aware of this, they will seek a ex parte temporary risk protection order. Ex parte is a fancy Latin word that means only one party goes in front of a judge and asks for this thing. They'll seek this by going in front of a judge and filing something online called process called DocuSign, which we use here in Polk County and is used around the state. The duty judge will see this application. They'll make a decision if there's sufficient basis to file the risk protection order, and they will issue an order. Then law enforcement needs to immediately go to the individual who made these threats, because these threats have to be exigent. I mean, this has to be something that's imminent for law enforcement to try and get judicial intervention. They'll go and approach that individual, give them a copy of the order, ask them to surrender any firearms or ammunition that they have, and have them back in court. Law enforcement will be back, but the individual will be in court for the first time 72 hours after that order is signed. The purpose of that first of two hearings is for the judge to be advised that the reason, the exigent circumstances, the reason that he or she signed that warrant, that risk protection order, have been satisfied. We've taken the firearms away. We're giving this person the opportunity to cool down. The threat is eliminated. The Department of Agriculture gets a notice so that they can't go out and purchase another firearm during this time. And at that hearing, the judge will schedule a trial. And that trial will happen within 14 days of the date that that risk protection order was issued.
But the weapon's already been removed from the premises or from the vicinity of where the person is, correct?
Well, that's the goal, and that's why I keep using the term exigent circumstances. If you made a threat today, law enforcement needs to get that firearm out of your hands immediately.
Correct.
Now, we recognize we can't go to court and have due process on the same day, but 14 days is the fastest due process that exists in any aspect of our government.
So the process of going through and getting the order, you're an expert on it. You've done more than anybody else. What's the process, and how do you become involved, and what role do you really play?
So the private, all of the municipal police departments and I will work together on risk protection orders. The risk protection order, as it was laid out, and please remember that it was put together about 5 years ago. The legislature has not gone back and talked about it. They haven't tweaked it in any way. There's been no changes.
And I find that amazing.
It's amazing in any context, right?
Right.
So, I mean, if you bought a car in the first model year, you would expect that Ford, if you bought a Ford, would be editing that car every year thereafter based on the issues and the feedback that they got from purchasers. The legislature has not done that in this case. There's been very few appeals, which we'll also talk about, because appeals are an opportunity for the courts to look at these brand new laws and help polish off some of the rough edges. But my role, to go back to your question, the statute's designed to be done by law enforcement without the need of talking to an attorney. They can, if they have a belief that there's a substantial likelihood that someone's going to harm themselves with a firearm. And they need to have direct evidence of that, meaning a family member calls, they go and investigate, somebody tells them directly what happened, they make their own observations. They fill out a form. It's been codified down into forms like everything else in our society has, and they submit that to the judge. Where I get involved is immediately after the judge signs it, I get a copy of it, because I need to file the civil litigation that is triggered by the judge signing that risk protection order. So my offices in Bartow will get information from all over the county, from all these other police agencies, and we will get with the clerk, and we will begin this civil lawsuit process. Now, having said that, what we're seeing happen more and more is law enforcement will reach out to me before they make the decision to file and go through the facts with me based on, as you've said, having done this 600 times now, we start to see some outliers. We start to see facts that may or may not merit having a risk protection order, even though perhaps we could obtain one. The question really is, should we obtain one? And I'll give an example of that, if that's all right.
Please.
Most everybody has a cellular phone these days, and that includes kids. Kids at school, we have seen a tremendous number of people, middle school, everybody's got traumas and tribulations that they go through. They might text their friends something that their parents wouldn't use as far as language, I hate her, I wish she were dead, someone should kill me, just shoot me. These types of statements that really aren't in my vernacular, but are very common with younger folks. Maybe it's because of movies or social media or video games, but it's much more normal to use that type of language. When a school resource officer obtains information that somebody is making threats or statements to use a firearm, they've got to weigh and balance. Do I need to file a risk protection order? Remember that the basis for having this risk protection order was a student shooting, right? So on the other hand, students can't purchase firearms. And the risk protection order, and this is key, only eliminates the ability to lawfully purchase or possess firearms. So firearms that are obtained illegally or firearms that are obtained in some fashion other than purchasing them are not impacted by it other than when someone's caught with the gun. So a 13-year-old in middle school who makes these types of statements, an officer might call me. We might reach out to the parents, ask if they'll let us do a home search, ask if it's something where they have firearms. And if they have firearms, are they secured? Does the kid have access to them? Look at the kid's history, look at his mental health condition, maybe evaluate the circumstances a little bit more to determine whether or not a risk protection order is absolutely necessary. But make no mistake, you can file a risk protection order when all of the elements are present. There's absolutely no reason not to do that. When law enforcement exercises discretion, they put a little bit of liability onto themselves by doing that. So it's a constant balancing act between, do we want to burden the system with another RPO case, because we have so many?
How long do they take you say burden themselves with time? I mean, I'm sure there's times before court. How long is a typical court hearing for you to go in? Is it a 45-minute hearing? Is it an all day? Is it a 3-day?
That's a great question. What we've seen early on when we were putting this together was we had, when I say we, the clerk's office, the chief judge, Ann Gibson at the sheriff's office, who was their general counsel, who's now a county court judge, and I worked together all the time as committees trying to figure out how we are going to do this in Polk County. What judges are going to be assigned, what courtrooms are going to be assigned, what about bailiffs, what about the clerk's office? I mean, how are we going to make this work? Because this was one of these unfunded mandates. It just appeared, it appeared in a hurry, it had all sorts of issues to it that were just bigger than the moment.
It sounds like y'all were doing what the legislature should have been doing in refining this.
The legislature, in their haste to put together fast legislation, doesn't necessarily always put together good legislation. Right. And that's where it's incumbent on the legislature to follow up with it in the years that follow, right. Listen to the feedback from the parties involved, and maybe have the courts, in the theory that our theory of our constitutional government is the courts review all legislation, and that's where we end up. And so in this case, we haven't seen a whole lot of that. So to go back to your question, we've seen it takes about 8 or 10 detective hours to do one of these cases from start to finish. So from me, from the perspective as an attorney, it'll take me an hour and a half to do the necessary paperwork to begin the suit, to do the interviews and speak to the witnesses and coordinate things. I have excellent staff at all these offices that help do that. In the courtroom, some of these hearings take 3 minutes. They don't take any time at all. And some of them are full-blown trials that might take several hours, plus the preparation necessary to get those witnesses ready for that trial. When I say several minutes, remember, this is a civil matter.
Right.
And if a civil matter, if somebody doesn't respond or they don't show up to their court date, they lose their case. They get a default judgment placed against them. So some percentage of the cases that we'll have, which we do on Tuesdays and Thursdays every week, when people come in to have their case called, they're not there. And even though our judge currently, Chief Judge Yancey, who's hearing these, allows for people to appear via Zoom for the first hearing, if they don't appear for the second hearing, for the trial, then there'll be a default. And so that hearing might take 3 minutes. But they're offset by the ones that are full-blown trials.
Is Yancey the only judge who's hearing? Because, I mean, we have drug court, we have veterans court. Is there an RPO court or a judge who, kind of like yourself, who specializes in this and has heard so many, they've got a lot of institutional knowledge when you bring the case forward?
So the answer to that is both yes and no. So what we have done, unlike the legislature, the 10th Judicial Circuit has refined the system.
Okay.
Remember, we planted the seeds 5 years ago with that group that I was talking about. Don Jacobson, who was the chief judge at the time, worked hard to put some of those systems in place. Initially, they assigned judges who were doing dependency court, which is a type of family court, and they would take time off their docket And one judge would do a hearing on Tuesday, one judge would do it on Thursday. Those dates have changed. We've done them on Mondays and Wednesdays, but currently we're doing them on Tuesdays and Thursdays. Later, when Chief Judge Ellen Masters came in, she felt it was more appropriate for one judge to handle the case, and she appointed herself to do that.
Okay.
So that created the institutional memory that I think is very important to tell what's a good case and what's a bad case. And so after Judge Masters rotated out, our judges, of course, rotate every 2 years or so, Judge Yancey was elected, and then he's the judge doing them currently. Of course, if they're tied up with something else, we'll have a guest judge come in. They cover for each other, of course.
Todd's podcast is sponsored in part by SVN Saunders Ralston Dantzler Real Estate. Since 1996, the firm has offered unrivaled brokerage services throughout Florida, Georgia, and Alabama. With over 90 expert advisors throughout the region, our team has the knowledge and resources to help clients realize their most ambitious real estate investment goals. When you choose SVN Saunders Ralston Dantzler Real Estate, you have access to a diverse suite of commercial and land services, including forestry consulting, land management, auctions, property management, commercial leasing, and negotiating conservation easements. If you're seeking to invest in land or explore commercial real estate opportunities in the Southeast, contact us today at svnsaunders.com or call 877-518-5263 to connect with an advisor today. Once again, that's svnsaunders.com or by phone at 877-518-5263.
So you kind of act almost as a prosecutor, and I'm very inarticulate when I say some of these things, so please forgive me, but someone's got to represent law enforcement to bring the case forward, and that's kind of your role, correct?
That's exactly right.
And if am I called the accused? Am I called
You're a respondent.
If I'm the respondent, do I get an attorney? Do I have to hire them? Does the court appoint one to me if I can't afford one?
All good questions. So this is civil, and I've said that 3 times now. That means you do not receive the benefit of a court-appointed attorney like you would in a criminal case. So you would need to obtain your own attorney if you planned to do that. And we do have infrequent appearances by many qualified local attorneys who come in and handle these types of cases.
Right.
But here's the hitch to that is that, remember, this is fast due process, right? We're moving forward to a full-blown trial in 14 days, witnesses, depositions, any rules that might be applied to a civil case, which could be written interrogatories, requests to inspect, you name it. And I get to call the respondent as a witness. I, as the prosecutor in a criminal case, can never call the defendant.
Correct.
But as nominally the prosecutor in a civil case, I can call you and question you. Now, you can't not answer. You could take the Fifth Amendment and say whatever I say is going to incriminate me.
As the respondent.
As the respondent. But the judge will get the ability to gain a negative inference.
Okay.
That's a fancy legal term that we pay a nickel for, which says, if you take the Fifth, I'm going to believe your answer was the bad answer.
Right.
So I think, to go back to your question, when I'm presenting those cases, if there's a defense lawyer involved, a lot of these cases are associated with a criminal case too. If somebody's made a threat to use a firearm to somebody, that might be an aggravated assault, or maybe it's an aggravated battery, or maybe it all stemmed from a criminal case. And if there's a criminal case, it is not going to trial in 14 days. Right. It's going to take the full 90 days, 180 days or more to work through the system. Many respondents, defendant in the criminal case, respondent in the civil case, they don't necessarily find it in their best interest to testify during this risk protection order. Because all I'm asking the judge to do is say, I do not wish this gentleman to have a firearm for the next 12 months. No access to guns, no access to ammunition. That's the sole tool that is in our toolbox, and that is the ability to civilly say, we're suspending your right to have a firearm for 12 months. Many of these guys on the criminal cases, guys, women, whoever it is, They don't care about that because they're going to be tied up on their criminal cases
Right.
where there's other rules affecting them and their ability to own firearms, pretrial release conditions, bonds, that sort of thing. So those folks aren't necessarily going to defend themselves in a risk protection order.
But is it 12 months or nothing? Or can the judge say, hey, come back and see me in 2 months. This may just kind of be a temporary bad day for this guy or this gal. Let's readdress it in 60 days and maybe I'll lift it? Or is it, once you get it, you're adjudicated for 12 months?
Now, that's a very insightful question. The penalty is up to 12 months.
Okay.
So the judge could, in theory, say, and we do this, and we've seen this. A judge might come in and say, we got this, the facts that got you here today were your worst day ever.
Right.
And it's clear to me that you're responsible and you're working on yourself. You're in counseling, you're in treatment, you're addressing whatever happened. Why don't we wait and see what happens in 90 days, 6 months? Have your counselor come in here and tell me what progress you've made, things like that. And the judge would take that into consideration at a later time. And this is important too, and I know we didn't talk about it yet. Even if a risk protection order is granted, every individual who has a risk protection order has the ability to have it set aside during that 12 months on their own motion. They can file a letter to the court. That's how it's practically done.
Right.
And say, you know what? That happened 3 months ago. I'd like to come back in and have it ended early, and let me explain why. Now, the burden will be on them to explain why and to show the evidence in the case, but it's up to 12 months, and it can be less.
Do you, as the prosecutor or whatever, go back on behalf of the respondent and say, hey, judge, this person has met a lot of these things, I think it's okay? Or does that respondent have to be the one who brings it forward? Or can the judge just say, in 90 days, come back, and David, you're going to be on the other side, and the respondent will be here, and let's talk about it again?
It could be any of those versions. The burden is on them to present evidence that they no longer meet criteria. I find in my job, I think to do it in the form that I'm most comfortable with, I spend time talking to individuals with risk protection orders. These aren't criminal cases. These are civil cases, and I provide a lot of information. And sometimes I will provide hints about how to move forward in cases. And I'm not going to cross-examine somebody when they come in and ask to have their RPO terminated unless, in my opinion, the facts still warrant it being in place. I mean, it's their burden. I'd like to see that they make progress. The goal is not to have everybody in the world having risk protection orders. The goal is for individuals who meet criteria to move past that.
You've mentioned that it's a civil matter and not criminal, but it does dance around, it touches the criminal side just a little. How is that? How does that work on something like this?
Another good question. So some of
Eli, can you mark that? That's about 12 times he's had another good question, a great point.
I'll make notes.
Okay.
take those out, huh? Sorry.
No. I want those bragging on the commercials.
Those are earmarked. So, that's another good question. And the reason why this is such a challenging statute is it's found under Florida Statute 790.401. It is a hybrid between civil litigation and criminal litigation. And it stands out as an outlier, and it's the only statute I know that has this. It's somewhat like a traffic ticket in its inception, but the teeth that are given to the judge convert it into a third-degree felony. Now, a third-degree felony is punished by up to $5,000 fine and 5 years in prison. So if you get a risk protection order, it's all civil and the civil rules all apply. But if you violate the risk protection order, you're going to be charged with a third-degree felony. If you lied in the course of the presentation of evidence in the risk protection order.
I, as a respondent, say something that is a blatant lie that everybody knows I'm lying, that then brings in the felony side of it.
That's going to be a third-degree felony as well.
Okay.
One of the other aspects of it that makes this an interesting hybrid is that if law enforcement believes that you have firearms and you haven't turned them over, they could obtain a search warrant. Now, there's no other civil search warrants that I'm aware of in our Florida Constitution. So this is a civil case where a judge is going to go in and say, you know what, I'm going to order law enforcement the ability to go in and search your house and obtain these firearms. So the carrot and the stick approach is, hey, do well, be good. 12 months from now, this is going to naturally expire. You don't have to come back to court. If you violate it, you could go to prison for 5 years.
So you've done 600 of these. Does that sound like a fair and equitable compromise between the civil and the criminal? Is, hey, if everybody plays good with each other, if everybody's honest, we're going to get to a good outcome. But if you lie, there's got to be some teeth, and there's not the teeth on the civil side. Is that, you think, a pretty good compromise?
Well, I'm not aware of any prosecutions that have occurred beyond one or two in 5 years of doing it. And the prosecutions that I'm aware of were related to people obtaining firearms again, not for misstatements. So I personally, as as someone who likes the Constitution, who teaches the Constitution, as you mentioned, both here and abroad sometimes,
Right.
I'm uncomfortable with it. But that is, as I think I've said this before, these are the tools that we were given, and we simply have to do the best we can with them. It would be my preference for the court to potentially use contempt powers. In civil cases, typically if you violate a judge's order, you're held in indirect or direct civil contempt, and the judge can punish you by putting you in jail up to 180 days. Well, 179 days. If you ask for 180 days, there has to be a trial on it.
Right.
But I certainly understand why the legislature did it the way they did it.
So you had mentioned the officers come to the door, they ask for the guns, they talk to the parent or some other person there. They take whatever guns may be owned by the respondent, but they don't take all the guns in the house. So just because you've taken 2 guns or 3 guns away from the respondent, there still may be access to those weapons by other people that are living in that home or working in that office or wherever the situation is. That correct?
Yeah, that is another interesting aspect to this, which is the RPO only applies to the individual respondent. And
not everyone living in the home.
yeah, it's phrased to say you, Mr. or Mrs. Respondent, may not possess in your possession in any form or fashion, have control of a firearm or ammunition. Now, we've said kids, certainly most of these are adults,
Right.
but other individuals in the home, a wife, for example, who has a safe and can secure a weapon, she doesn't lose her access to that weapon. However, if husband knows the combination of that safe and he's got a risk protection order and he obtains that firearm, he gets the violation that we mentioned, which is a 3rd-degree felony. Interestingly, the statute does not address anything about that other individual who owns that gun in the home. Meaning, another aspect of this I think might be appropriate to comment on is if an individual has firearms and an RPO is formed, they could turn those firearms over to someone other than law enforcement. They can turn those firearms to a family member. And as long as that individual
Secures them.
then there is nothing wrong with that form,
Okay.
except, and this is, I think, what I'm always worried about, nothing keeps that individual from giving them back.
Correct.
And there's nothing in the statute that criminalizes that behavior.
So it sounds like, and I don't want this to be a Second Amendment podcast because that's not what we're here to do, but it sounds like we're kind of dancing around it. The law was almost constructed to try and protect the Second Amendment, but it was also to secure someone who may not be stable from owning or possessing a firearm until they can prove that they're stable. Is that do you think that was kind of the intent of what they did, or do you think that was an underlying factor as they were going through committees, legislation? Do you think they succeeded?
So the original intent was, in my opinion, to fill in a gap in the existing laws. We had existing laws that said if you've been Baker Acted, you have mental health problems, that we're going to limit your access to firearms. And while you're in a Baker Act or have mental health adjudication of some kind of mental health issue, the Department of Agriculture, which oddly is the agency, of course, in our state which regulates firearms, the Department of Agriculture becomes aware of that, and they preclude you from being able to lawfully purchase firearms or ammunition. In the Marjorie Stoneman Douglas case, as I understood it, the individual had a long history of mental health statements, mental health issues, mental health findings in various courts. None of that, after he turned an adult, was on his adult record. All of that history I was talking about was juvenile. And of course, we use a different juvenile system in our the way we have our Constitution structured. So almost all of that information remains secured. It's not sealed or expunged. It's just isolated so the general public doesn't get access to it. So the gap that existed for him was they had a long history of him making threats about wanting to use firearms to harm people. But once he became an adult and he was old enough to purchase those firearms, they didn't have any record that they could use to preclude him from doing that. Hence the RPO was, if you as a law enforcement officer have heard a threat, we can have this risk protection order which will extend 12 months, and let's keep you from getting those guns during that 12-month period. I think we've called it a cooling off period perhaps while we've been talking about it. But the reality is, if you're mentally ill, if you want to use a firearm, you can find a firearm illegally.
Right.
And all we can do is help cool down people, in my opinion, that probably weren't going to use them anyhow. Those very few people that are teetering on the edge that may have gone down that path, we're stopping that.
It makes them think one more time.
I think just going to court and being in this process of hearings and police officers and judges and just the gravitas associated with going into the court system has a strong deterrent effect.
I think it's hard to quantify the number of things that you that you stopped, that you prevented, be it a suicide or a shooting. Overall, do you think it's been an effective tool for law enforcement, for the courts, for people to cool off? It's almost like one more step for them to do something, and maybe it gives them pause, whether it's going to court or whether it's having the police show up at their front door and saying, surrender your weapons.
I do think it's been effective.
Good.
And I think it's been effective, and I don't have the ability to quantify that and say, you know what, I've talked to other individuals about this. How many suicides were there in Polk County in the last 5 years with a firearm? How many were there before that? We just came through what for many people is a very challenging mental health time in the history of this country. So it's difficult to quantify and pick a number. But I can assure you that the people that have lost their firearms have never used a firearm to harm somebody after an RPO has been put in place. And that has some value in itself. But I think another important factor to consider is that probably 50% of the people that come into RPO court, they consent. When they come in, they've had their firearms taken, they've gone through the process you and I have described. Law enforcement's knocked on their door, asked them to surrender the firearms, explained to them the circumstances. And when they come into court that very first time, they'll consent, recognizing that at the time, what they were saying and doing certainly was not appropriate.
Is there any empirical data that once they go through and have the RP order granted, does it encourage them? Does the judge encourage them to seek some professional help? Are there avenues for that individual to say, I really do need to talk to someone, whether it's clergy, whether it's a professional mental health counselor, psychiatrist, whoever that is, family friend. I'm not dealing very well with this on my own. I've got to talk to someone.
So the court also has the ability to order a mental health evaluation and treatment as a component of risk protection orders. And of course, the court and the clerk's office and many of the mental health facilities that are available in Polk County become aware of this. The judge, typically every judge we've had, recognizes that these are unique circumstances that bring an individual before them. And that discussion takes place in many, many cases. Most individuals are hitting close to rock bottom by the time they get a statement where they're going to harm themselves with a firearm. So the very fact that they have been brought into court and that process starts, maybe that's the opportunity for them to start moving back up, seeking that help. It certainly makes their families aware of the problem, because another aspect of this act is that law enforcement has to notify immediate family about what's happened. And I think that probably has as much effect as the court statements.
Hey, listeners.
Hey, everyone.
Hola.
Hi, all.
Hello, everybody. Hello. This is Rob Palumbo.
This is Fred Hyde.
This is Juliet Ashley Vide.
Dr. Angela Garcia Falconetti.
This is Congressman Scott Franklin.
This is Margie Grant.
This is Jake Palumbo.
And I want to thank you for listening to Todd's podcast.
Thank you for listening to Todd's podcast.
Thank you for listening to Todd's podcast.
Please make sure that you like and or subscribe.
Don't forget
Don't forget to subscribe to Todd's podcast on your favorite podcast app. Tune in and listen.
Join in and listen to us.
Thanks.
Thank you.
So if the court orders this individual to get an evaluation or whatever, and they're indigent or they don't have the money, does the court pay for that evaluation? When it's a civil side, is they got to pay for their own attorney. But if the court orders it and I don't have any money to hire a mental health counselor or go see someone, does the court already have contracts with different mental health counseling organizations that says go see Peace River, go see this person, or go see this company?
Well, I think you alluded to it earlier. As you know, the courts have a lot of different subgroups, Marchman Acts, Baker Acts,
Right.
Treatment for veterans and other groups, and they do have relationships with those organizations for assistance. But you also put your finger on another component, and we're not paying for it. The motivation for this individual is if you want to get your firearms back, you're going to have to shoulder this burden and take these steps yourself with you and your family. And if you want to get done sooner, then you're going to have to get that done and come back to court and show me why I should terminate this early. Otherwise, after 12 months, the RPO naturally expires regardless of whether the person has shown any progress. Now, law enforcement does have the ability to look at a case as it's expiring and determine whether to extend the matter 1 year. The Lakeland Police Department, for example, whoever the detective is that handles the case does a quarterly review of the progress of the individual in the risk protection order. They go meet with them, see how they're doing, see if the challenges still exist. And so at the end of a year, we're able to look back at their progress and decide if we need to keep it in place 1 more year.
Could some of that counseling that a respondent goes to, could it be a preacher, a clergy, and that may or may not have any real training, but they run a church, and the respondent goes back to the judge and says, man, I've been talking to my preacher once a week. I'm making great progress. They then bring the preacher in and say, hey, has John or Mary or Todd or Sue, are they really making progress? Or, I'm kind of intrigued by the whole process and how we protect the people, because I think that's the ultimate goal, is to help them get better, but in turn, protect our society.
Yep, they can certainly use whatever means that they want to and whatever witness they want to, and it's going to be up to the judge to weigh and balance, how much weight to give that testimony. I earlier mentioned, would I cross-examine a person who was coming in those circumstances? And the answer is I would in every case, but what I ask may or may not be different. If the pastor's in there, I might inquire, well, how often are they coming? How frequently are you discussing this? What progress have you seen? And then the judge will weigh and balance that. Now, because it's a civil case, remember that I'm going to use a fancy legal term, the standard of proof. Everybody knows that in a criminal case, it's beyond a reasonable doubt. In a civil case like this, it's called clear and convincing evidence. So it's a little bit higher than the scales of justice tipping in your favor, but it's not as high as reasonable doubt. In fact, there's some interesting aspects of this that you and I talked about before we got started today, where there's another standard of proof used that's never been heard of before, and that's called reasonable cause. And that's the standard that judges use when they're going to grant that temporary, what I call the ex parte hearing. When the person calls the judge at night, the law enforcement officer says, hey, I've got a case, these are the facts, and the judge has to make a determination of whether or not to give this temporary risk protection order. The standard that they're to employ at that point is called reasonable cause. And frankly, that's just a made-up term that none of us had ever heard before, and so the legislature hasn't helped us refine that. Courts haven't helped us refine that. It's somewhere less than probable cause, which is what we need to arrest somebody.
Right.
It's a little bit similar to what police use to get to probable cause, something called reasonable suspicion. So my point being, it's interesting that there are different burdens of proof in this law as well.
What I've found interesting in researching this is everyone's trying to get to the right decision. It's not just to take the gun away. It's really to come out what's best for the respondent and the family situation. And, that's what I've taken from listening to you today, from listening to our conversation the other night and doing the research. Are some cases that you've heard more difficult than others? Do some just tug at your heartstring, or is it pretty black and white when you go in and you say, Judge, this person really does not need to have a weapon right now?
There are outliers on both sides.
Right.
I might have a case, and I had a motion to extend a case yesterday. The individual told their family and friends that they were suicidal. They told them that they had obtained a firearm. They told them they were going to go and harm themselves with a firearm, and they went and shot themselves. And law enforcement was able to get there by the coordinated efforts of the families concerned, because they'd called 911, and they saved that person's life. That person recovered and was able to start integrating themselves back into society. But that was a very black and white case, that this is a person who was a substantial likelihood to harm themselves with a firearm. So when after a year had come up, I asked to extend that, because that person had not shown any adequate development, in my opinion, by talking to counselors or continuing with treatment. And they had actually harmed themselves with a firearm. So we asked to extend that. That person came in and consented. They said, you know what, you're right. I'm still in the process of rebuilding myself. So that would be a black and white case on the side of, that was pretty heavy. The facts were heavily in favor of an RPO. There's also there's ones that do tug on your heartstrings, if that's what you're getting to. And one of those factors might be a child who makes a statement. Let's talk about maybe a single parent family, and a child who's going through challenges, who might be, 13, 14, or 15, who, makes a statement that qualifies for an RPO, and we bring the case, and the parent doesn't have any firearms, but the school's involved, and this person's made this statement to other people, and kids in school know about it, and they've got a bit of a pariah circumstance going on, and the ROs, resource officers, are concerned about it because they've made statements before. And you can sense that there's real challenges for this youth. They don't have resources and they don't have the finances, potentially to satisfy what would be necessary to avoid an RPO. The downside with some RPOs is that once they're put in place, because they're civil, they're not criminal, they could never be sealed or expunged. And those are just fancy legal words we use to talk about having your record erased. So
say that again, because that was, I think, my next question. I just wanted to. So if you're a juvenile, this never goes away, or it's not expunged. It's just sealed at 18.
If you were in the criminal system, we have a juvenile criminal system.
Right.
Juveniles, until they're a certain age, have not developed like adults, so we don't hold them to the same standard. So anything that a juvenile does on the record goes through the juvenile justice system. In rare cases, like the state attorney will have to weigh and balance to charge a juvenile as an adult if they've done certain, significantly serious criminal actions. But most criminal cases are in the juvenile system, which is always sealed for the general public. So when you become 23, 24, 25, you are not part of the criminal justice system where someone's going to look at your record. But anybody in the criminal justice system has the ability to have their record sealed by a motion of the court if there was not a finding of guilt, meaning they withheld guilt or they gave them some other compromise. And that means that record could be sealed. Like you or I having our first offense, a judge may give us the benefit of saying, I'm not going to put it on your record just yet.
Right.
Let's see how you do. This is civil. There is no sealing in civil records, whether you're a juvenile, an adult, an elderly person. So a juvenile who, 15, 16 years of age, makes a statement to use a firearm, has an RPO put against them, well, those records are open to the public. And in the example that I was using, if mom is trying to get assistance of, some services in the community, what's always going to appear against her is that her child was found by a judge to be substantially likely to harm themselves or someone else with a firearm. And that will follow around, that will be on their record and follow them around forever.
So you mentioned Baker Act a few minutes ago. Does a Baker Act follow you around, or it's not the Baker Act itself, it's if there was a weapon involved, that was the trigger that follows the single mother around, or whatever example you said.
Baker Acts have their own built-in
Right.
privileges and exemptions. In our legal system, we have, Florida has very, very liberal sunshine laws, which means our government's open. You know this from your time working in it. Law enforcement records are open. Everything is wide open to a public records request. Law enforcement spends a tremendous amount of time answering public records requests. But there are also exemptions, and there's material that is privileged as found in statute, and it's constantly getting more complicated. We changed the Constitution a couple years ago with something called Marsy's Law, And nobody seemed to think about at that time that by keeping a victim's name private, we weren't able to release that record in what we used to be able to do in a sunshine law request. So the media would come to a law enforcement agency and say, hey, what happened? And we can't answer that anymore because we changed the Constitution. That's painting with a very broad brush. My point being, there's plenty of exemptions and exceptions to these public records law. Baker Acts are exempt from public records law in many ways. What's not exempt is law enforcement writing a report and saying, hey, I met with so-and-so, they meet the criteria for Baker Act, I took them to the facility. That record is open, but beyond that is not.
Sorry, I'm jumping around a little bit, but you can get a temporary restraining order for 12 months, and then it can be extended for another 12 months. At the end of the second 12 months, do they automatically get their weapons back? Is there a tool for law enforcement, for the courts to continue to keep this individual from obtaining a firearm?
It's vague. The last chief judge, Ellen Masters, interpreted that as saying you could do a one-time extension. The current chief judge interprets that as endless.
As many 12
extensions.
months as you need.
That's right. And if we had some appeals from higher courts that have weighed and balanced some of these issues, we'd know which of those two judicial opinions was the one we were going to follow. Currently, we follow whatever the chief judge tells us to do. So at the end of the 12-month cycle, it automatically expires. The person goes back to law enforcement. They pick up their gun or their firearm there, and they're on their way. If we do a motion to extend, it might be longer than that. That motion to extend could also be for 1 month, 6 months, 9 months, 12 months. Again, the judge has the latitude to do that.
Who can report someone? Does it have to be a family member? Does it have to be an officer of the court? Could I report Eli because I heard him being really mad at one of my other partners? And if I can report anyone or you can report anyone, are there any consequences to me if, Eli's found he doesn't have a problem? I just made it up because I was mad at Eli because he left early today.
Well, that's another good question. Anyone can report it. It doesn't require, it's not a family law matter. It doesn't require personal knowledge. Anybody can report it, but law enforcement still has to feel that there's a substantial likelihood. So they're the initial arbiter of what weight to give that. But it's important to note that the statute says that there is no liability on law enforcement or individuals or the court system of any kind for bringing a risk protection order. So like what you were alluding to when this first started, I've done a lot of cases around divorces, and sometimes divorces bring out the worst in people who used to love one another. And we've seen people need to get injunctions for protection. And sometimes maybe they abuse that a little bit, they exaggerate a little bit, but their emotions are so high that they go in front of a judge. It's not just enough to have the divorce, but I also want this order to keep him away from me or keep him away from the children. I anticipated risk protection orders were going to go that route, which was in those family law cases, people were going to say, well, I'm going to take her guns away. I'm going to take his guns away. He loves to go out and shoot that shotgun. He competes in all those sporting clay events. And I'm now going to make a claim that he did that. I haven't really seen that abuse. RPOs have remained pretty much independent, and I have not seen many people try and claim an RPO as punishment for someone else.
Hey everybody, this is your host Todd Dantzler, and I hope you're enjoying this episode. I would like to take a moment to do a shameless plug for my real estate business. As most of you know, I'm a partner with SVN Saunders Ralston Dantzler Real Estate, but I am also a working broker who is very active in listing and selling real estate. I've been in this business for over 41 years. I know, you're thinking he can't be, he's so young looking, but no, it's true. I've been actively listing and selling commercial real estate my entire working career on properties ranging from ag land to multifamily projects to office and commercial and industrial properties. I have held the distinguished CCIM designation since 1991. This is the highest designation you can achieve in the commercial real estate field. I believe that a big part of my success in the real estate business is because of the relationships that I have fostered throughout the state of Florida and also right here in Polk County. So if you have any real estate needs in buying or selling, please give me a call to see if I can help out. My direct line to my desk is 863-877-2846. Again, that's 863-877-2846. In doing my research, I think Polk County has brought more RPO cases than any other county in the state, and Florida perhaps has brought more than any other state in the nation. Is that an accurate reflection?
I think so. I think we had somebody brought some numbers to my attention that there was probably over 3,000 risk protection orders out of Polk County since this thing started.
And how many are I'm sorry, finish your answer then.
Oh, no, that's all right. And I think there's been 12,000, 15,000,
right,
in the state, and that's certainly more than other states. Occasionally I get contacted by other states that are starting red flag laws, and they might ask questions like we're doing now. What are the highlights that we should be looking for? What are the lowlights? How do we sculpt these things? But yeah, Florida leads the nation, and we lead Florida.
And how successful are you? You say 50% voluntarily of the respondents, typically 50% just kind of voluntarily say, yeah, I need some help. I need to cool off. Please take them. We'll come back. So the other 50% that you have to go and get a judge to give their opinion, how many are you successful at? How many does the judge say, I think you reached a little too far, law enforcement, I'm not going to grant it right now?
So there's a significant percentage that also default, that they don't show up.
Okay.
And out of the, let's say 20% go to trial.
Okay.
And I think it would be reasonable to say that 35, 40% of the people will win their risk protection order trial. It's not a judge saying, law enforcement, I think you overreached. It's typically, now that we've had time and objectivity over 2 weeks to coolly look at this,
right,
I don't think it quite rises to the level of clear and convincing evidence. It clearly met the criteria of this very low reasonable cause standard. And so I think you should see, I think it's natural with the way that we've worded the statute, that there should be some success at these trials. We don't want to be winning all these trials, or we're not being fair and equitable,
right,
I think, in the way they're applying the law.
I think that was a much more articulate way of saying what I tried to say. The RPO law that came out in Florida is a result of the tragedy in Parkland. Is that typically what it takes in these other states to say, hey, we just had a mass shooting, who's the expert? Hey, David's representing, law enforcement. He's not a lawmaker, but he's a law enforcer. Let's talk to him and get his opinion. Or are some just proactively saying, hey, this seems to be working in Florida a little bit. Maybe we need to start getting out in front a little bit?
I think even in answering that question, it probably overstates kind of the significance of my role when people ask questions, but I'll try and answer that anyhow. It typically takes those mass shootings that we've seen so much of over the last few years before people will balance the very established interest in people who want to have firearms and use firearms versus the people who are abusing that. And I think when legislatures are finally faced with something that is just inconceivably, terrible, then they finally say we need to do something. And this is something. It's not a cure-all. And I think it's important to note that many of my friends who are firearms enthusiasts, I myself have a federal firearms license, which
right,
means I sell firearms. My clientele is limited to law enforcement and school teachers and acquaintances.
Right.
So I don't have a business. I don't stock weapons. I'm kind of a conduit. I'll do your paperwork for you. So I guess it makes me a gun enthusiast myself. I'm comfortable with the way this law is applied. I have yet to see a gun enthusiast come in and lose their firearms in an RPO, because everybody I know or have ever met that is a gun enthusiast or a firearms enthusiast holds themselves to a very high standard in how they use that gun. They've trained themselves in some form or fashion, whether they have a concealed weapons permit or just classes. Now that we have constitutional carry and anybody can do it, maybe this is going to change. But for now, I've never met an individual come in for RPOs that was a professional gun enthusiast.
Have you ever seen anyone abuse the law that may be anti-gun that says, I'm just going to start naming everybody? That's why I asked earlier, is there any repercussions if I turn someone in and it's found out, hey, if he's turned 20 people in and none of those 20 have ever been found that they need to have them taken, maybe we should stop listening to Todd when he calls in and turns someone in. Is it being used as a tool against the Second Amendment?
I have not seen a single episode of that. But most importantly, that exists in the statute for that abuse because that person has no liability. And so, if somebody was a serial, tattletale,
Right.
I suspect law enforcement would weigh and balance it when they call me at the beginning and we talk about the facts and the evidence that we have and exercise the discretion that we might choose to exercise. Discretion sometimes is a dirty word in the legal system. Discretion creates liability. In many ways, all RPOs are doing is, with the goal of making society safer, they're moving the liability down the chain to an objective judge, very quickly, so that we have heard opinions of the neighbors who heard it, opinions by law enforcement who investigated, opinions by the judge who evaluated the temporary risk protection order at that lower standard, and then the whole civil discovery process and now a trial in front of a judge. The truth tends to come out. And if there's an abuse, then it's probably going to be cleared up by the time it gets to that judge. And in my experience, it's been cleared up every time.
If someone is thinking, hey, I'm really concerned about this family member, I'm really concerned about my friend, who do they call? Do they call? Is their first call to law enforcement and say, hey, I've got a brother, I've got a cousin, I've got a friend, they're struggling right now, and I know they have a gun in their possession or weapons or whatever. Could you send someone out, or what starts the process?
Typically that 911 call. So the way our clearinghouse works, we have, communication centers, and, Grady runs one.
Right.
And of course, Lakeland has a secondary comm center. 911 calls come in, they're divided out to the municipalities or the sheriff. They typically send out a deputy or an officer.
Right.
The officer starts to weigh the information. I understand the sheriff does this the same way. Then they'll call a detective with more experience and they'll respond.
And so they open the case, so to speak. That may not be how it's.
I think that's exactly how it's said.
Okay. And then they begin the investigation. If it warrants, hey, we really need to get in front of a judge. We need to, first they'll go talk to the person or the respondent to find out what's going on. And then if they determine that, hey, we think we need to take this weapon, can they take it from them right then? Or do they then have to get in front of a judge and wait 14 days for the judge to say, hey,
it's not 14 days, it's immediate.
Okay, so they can take it immediately if they think there's an immediate risk.
Well, they would stay on the scene until they have the temporary ex parte order in hand, or digitally in hand. So typically they would stay and control the scene, make sure nothing's happening right then. Their partner, somebody else, goes online, they file the information, they get an answer back from the judge. The judge says, okay, I'm giving you a risk protection order. It's almost immediate. It might take an hour, it could take less, could take a little bit more, but they'll stay on the scene and control the scene until that happens. Because, think about it. If I'm making statements to harm you with a firearm, the cops come and say, hey, we're going to come back maybe and take it. I think that motivates you to use it.
And that was part of the timeline that I didn't fully understand when I was researching this. Are you part of that first hour, or are you part of it once they take the weapon and then it goes to court? That's when you are engaged. I know you're engaged because you're helping with training of the detectives and of the deputies, I'm assuming, and you're all working to be better at it and working at the process.
Well, let me be clear. Sheriff Grady Judd has 4 full-time attorneys that work for him.
Right.
He's got general counsel and deputy and assistant general counsel. So the sheriff does their own work, although certainly we're doing it at the same time.
Right.
I would not be involved at that initial stage most of the time. If it's something unusual that requires, maybe a second opinion, a more objective opinion, they'll call me or text me, 24 hours a day, and we'll kind of walk through it. My default, remember, though, is I don't wish to take on any more responsibility for somebody's bad decisions either.
Okay.
If they meet criteria, we're not going to try and not do an RPO. If they meet criteria, we're going to get that temporary risk protection order, and we're going to be in court in 72 hours. And in 72 hours, that person's going to be there too. We'll have a much better understanding of what's happening in those 3 days.
So, and just kind of wrap it up, you've been very generous with your time today. Is there a website with resources? Is there a place with resources? Is it your law firm's website? Is it the sheriff? Is it the LPD? How does someone do a little more research on this to say, I think I might have a problem in my family? Or should they just call 911 and start it and then let it sort out from there?
First, I would always say call 911.
Okay.
I think that's always the safest choice. But Florida state statute is found, and again, I've cited it erroneously a minute ago, 790.401 talks about how the risk protection order works. The 10th Judicial Circuit virtual courtrooms list risk protection orders, and you can click on those and actually watch those hearings transpire any Tuesday or Thursday afternoon at 2 o'clock. There's information on the state attorney's website. There's information on every law enforcement website. All law enforcement have pamphlets, I think I got that out that time, that they've made for risk protection orders that are available, and most of that information is posted online. And then, of course, there is the power of the almighty internet.
Right.
And, type in risk protection orders in Florida, and I'm sure you'll get opinions across the board, as well as steps and stages to consider. But for you and I, as lay people, if my brother's had one too many and he's out waving his gun around, I can deal with that. I don't want to get shot. But if I'm concerned, I'm going to call 911. I'm going to have trained individuals come in and help deal with that. And if there's sufficient basis, they may take that firearm away for 12 months.
Why is Polk County leading the state? Why aren't all counties doing this, or are all counties doing this? We certainly have counties with larger population that certainly have the same issues. Is it the will of law enforcement to do this, to take this law and try and make it a tool for them, or are they just overwhelmed with everything? I don't fully understand why, and maybe every county is to a degree, but if we're leading the way, there's certainly counties with larger crime problems or larger social issues than what we've got.
Right. There's several counties with a larger population, and you would expect if everybody was dealing with this as zealously,
Right.
then you would see their numbers higher. Pinellas County, Broward County, some of the bigger counties, they are close in numbers to us. But I think that, Polk County has the benefit of a very progressive government. When this statute came out, this was not something that we were funded for. It was not something that these agencies had an extra 8 or 10 hours of detective time that they could apply to each one of these cases. But Sheriff Judd, for example, made the decision that we know he's a gun advocate, we know he's a Second Amendment advocate, but this statute has merit, and the sheriff's office is going to aggressively apply it. The local municipalities lagged behind that a little bit. I mean, he set the example.
Right.
Now the municipalities that I represent are equally aggressive, in my opinion. Sometimes we use slightly different approaches. I mentioned some of the discretion methods that we might employ, but that's the reason why we've had, I have 94 active cases with law enforcement pending right now.
Wow.
Other counties you and I can't speak to, but you've been in county government. And small counties, small agencies,
Small resources.
an unfunded mandate, a department with 3 people, 5 people, 100
Right.
people. They simply don't have the resources to integrate it. Plus, sometimes they don't have a general counsel who relays to them how significant this is and the liability and exposure that exists. So it could be any one of those, it could be all of those. I think that Polk County leads the way because we lead the way in many things.
Yeah. Is there anything that we haven't talked on or that I didn't ask you that you said, I really wish Todd would have said this or asked me about that? Or you think we've done pretty good at covering things?
Well, dozens of things. We didn't talk about appeals and the lack of appeals. We didn't talk about some of the language in here which people find offensive. We didn't talk about, how some of those issues would normally go up through the court system. But we don't have that kind of time. You could
Right.
spend days
Yeah, perhaps
picking it
that's
apart.
another edition that we'll do to talk about that end of it.
But I think in all, we've given a pretty good overview of how the process starts, the thinking throughout it, how it gets in front of a judge, how it ends. And I really appreciate you taking the time to give me an opportunity to speak on this issue.
Well, this was great. I enjoyed it. I hope that everyone that's listening enjoyed it. We've got about 784 million listeners, give or take 784 million. And but it does go across the state, and I do have friends that are listening all around. And if you know someone who's struggling, please get help. You know, you're not in this alone, and you know, you've been a great resource and a great leader of this issue in our county and other things. So I appreciate what you've done for us, and I appreciate what law enforcement does in efforts to keep us safe. So thank you for coming by, David. Anyone needs your counsel, Dunlop, and Boswell and Dunlop and Bartow, appreciate it. You're a partner down there, and a great law firm that does a lot of good work for our county. So thank you very much.
Thank you, sir. It's a pleasure.
Hey, everybody, I want to thank you for listening to Todd's podcast. This has been your host, Todd Dantzler. If you enjoyed today's episode, tune in next time where we're going to be talking to Hal Wallace, president of Pallet One. Hal's going to be talking to us about Greek life at university campuses, leadership development, the importance of being part of a community when you go off to college with a plan. So I hope you'll tune in next time for our Todd's podcast with Hal Wallace. As always, don't forget to rate, review, follow, and subscribe to Todd's podcast on your favorite podcast app. If you have any questions for me or any suggestions for future guests, please call or text our number at 863-288-0944 or visit todddantzler.com. Again, that's 863-288-0944 or visit my website, todddantzler.com. I look forward to hearing your questions and feedback, and please take care.